My name is Kasey McCall Smith, and I am a senior lecturer in public international law here at Edinburgh Law School, and I am also the director of the Human Rights Program here. I'm going to go through some of the key terms that will be useful in terms of, as Naomi said, getting everybody on the same playing field. And this goes for every sector. There's a lot of confusion around incorporation terminology, and so I think it's useful if we all have a good starting point. That way we all know what direction we're heading, because if we're not all on the same road, then it's going to be a bit confusing. So today, hopefully, we will get through some of the key terms, and then we can answer questions about how these might be useful in your different programs of work. So these are all of the treaties. You probably, if you've engaged with human rights at all, you will know these are the core treaties that were promulgated through the United Nations or through the Council of Europe or the EU. I've put the dates next to those that the UK has actually ratified. So because it's ratified, that means that it is legally bound to implement these obligations. Now, that obligation is something that exists at the international level, so when we get down to the national level of law, it doesn't mean that the UK always does that. But the UK is no different than any other state. However, we're here today to make Scotland better at helping implement. So we are going to be thinking about these obligations in the devolved capacity of Scotland. So as you can see, the UK is party to the Convention on the Elimination of All Forms of Racial Discrimination, also referred to as the CERD, the International Covenant on Civil and Political Rights, which is the ICCPR, which very much looks like the European Convention on Human Rights, so they cover almost identical rights. In human rights treaties, there's a lot of duplication. So it's mutual reinforcement, and then we have particular emphasis on certain vulnerable groups. The International Covenant on Economic, Social, and Cultural Rights, so ICESCR, which has been a large focus of the Human Rights Task Force in Scotland. The Convention on the Elimination of Discrimination Against Women, or CEDAW, so that focuses specifically on many civil and political rights, as well as economic, social, and cultural rights, but specifically in the context of women. The Convention Against Torture, which is probably self-explanatory, so that focuses predominantly on criminalizing torture. The Convention on the Rights of the Child, the UNCRC, which is where we've had the most commitment from the Scottish Government, and that will be the first kind of major incorporation effort that we see taking place here in Scotland. The Convention on the Rights of Persons with Disabilities, or the CRPD, the UK has ratified, but I'm sorry to say has done very little to actually implement that convention so far. Then the two that the UK has not ratified are the Convention on the Rights of Migrant Workers and their Family, which obviously will be relevant, particularly in light of Brexit, and the Convention on the Protection of All Persons from Enforced Disappearances. They also have ratified, obviously, the European Convention on Human Rights, and then we also have the EU Social Charter and its applicability through EU regulation. And what will happen with that after Brexit remains to be seen. So that's just to kind of give you an idea of the legal instruments that the UK is bound to apply. So in the same way that we are bound to pay our taxes because the law tells us to, technically speaking, the UK is bound to implement these obligations. But because it's an international obligation, that adherence is always a bit less solid, I would say, at the national level. So incorporation, this is a graphic that Sophie and Veronica came up with, who you're going to be hearing from in terms of the case studies in a little while. And this summarizes kind of what incorporation and implementation is about. So there are three contexts, and you're going to see this throughout the day, but altogether, what we're worried about in terms of incorporation is the legal effect, enforcement, and cultural change. So those are all three things that we need to ensure that incorporation makes a difference to our rights here in Scotland. I, unfortunately, am only predominantly talking about the blue section, so about how we get legal effect. add graphics only recently because my slideshow was very boring by comparison and I had slide envy. So we've got a few more graphics to try to explain how incorporation actually works. So we have the blue treaty. So that is the obligations. It sets out, it's just like a bill that goes to the legislature, except it's at the international level, agreed by states, after lots of toing and froing and discussion, just like at the national level. What happens during that time is in the green area, which is kind of part of cultural change, in that loads of civil society organizations feed into this process. Politicians feed into this process in terms of what rights they think are important as they draft this treaty. And then simultaneously, once the treaty is agreed, advocates try, and I mean advocates not in the sense of the word as legal professionals, I mean all of you, people advocate, civil society advocates to states to get them to ratify the treaty, so to become bound. Once they have ratified, then we have this situation that's from the center part of this graphic, which is we have international law and we have national law. And depending on the state, there will be discussions about how these two laws fit together. So in the center bit, where there's overlap, is what we get with incorporation. And so what we're trying to do is broaden that and make it to the big blue circle on the end, where the international treaty, the obligations flow through and are encompassed by the entirety of the national law. And we've got little discussions, little bubbles about advocacy, so culture change and enforcement issues. So these are all of the discussions that go around. And so these are just kind of to keep with the color framings that you're going to see later in the case studies. But yeah, so we have international law and policy debates, incorporation, and then implementation at the end once we have incorporation. So incorporation is basically the most narrow form and concept of implementation that we have. It focuses predominantly on ensuring direct application and enforceability in national law. Implementation. So implementation is not just about the law. Implementation is about ensuring that you bring society along with you and that the policies and the guidance that are used by various agents of the state, so your local authorities, your healthcare providers, that they all are on the same page and they are willing to recognize the rights that are set out in the law. So that is the goal of incorporation, is ensuring that there is implementation. And all of this is in the glossary as well, so so you don't have to write a lot. Direct application, people often wonder what that is. Direct application, this is a debate that's had often about incorporation. Direct application means that those rights that are in the international treaty and that have been incorporated into the law will be directly accessible in court, okay? So they have the capacity of being invoked in front of a judge, because without the ability to enforce a right, you can't make rights real. I noticed somebody had Make Rights Real campaign. It's the hashtag that I love to use the most, Make Rights Real. And this is how we do it, all right? This is the starting point. And enforceability. So enforceability covers a range of issues. So it's not just about justiciability, though justiciability is very important. It's also about the administrative processes that you can use to ensure that proper procedures are followed and proper consideration is given to your right when you're trying to access it. And this is something that many people have a really difficult time processing, particularly when you don't know a lot about your rights. And this is very common for people that, why would they have ever engaged with this type of legal framework? And so a lot about incorporation is making sure that we clarify how rights will be enforceable. And so it's just to reiterate that that is not just about litigation. That's also about ensuring proper procedures for protection on the front end. Because really, litigation is always a last resort. What we want is proper protection on the front end so that people don't suffer rights breaches. So, well, here's a whole thing I said about enforceability. So it generally refers to the availability of institutions and procedures to provide a remedy for the breach. And I think it's important to think about the remedy in terms of human rights breaches, because unlike a lot of people and a lot of the critiques of why we shouldn't incorporate have been about it's going to cost a fortune. It's going to be, we don't want American-style litigation coming and people getting millions of pounds because they've had a rights infringement that's, maybe not something that has caused substantial harm, but is harm nonetheless. And that's not what this is about. Enforceability doesn't mean that individuals necessarily get massive payouts. Sometimes it's about a change in policy. And some of that is also just about ensuring that people are put on an equal level, or given the equality that they deserve through the various commitments of the treaties. So there are 3 different types of incorporation, and under these 3 general topics there will be a myriad of ways that we actually could incorporate. But the 3 most commonly discussed forms are direct, indirect, and sectoral or piecemeal. So I'm going to take you through those 3 different approaches, because some of them you might recognize, particularly the sectoral or piecemeal approach here in Scotland, which I'll talk about last. But it's important to understand that there are different ways that human rights can be incorporated, because depending on what your particular field of human rights are, there might be something that is distinguishable that doesn't need direct incorporation, at least that might be your position. And we understand, and as we've been developing this program for today, we've talked to lots of different organizations and understand that not everybody has exactly the same view, and that's okay. But why we're going to go through all of these different types is so that everyone is able to utilize the language that they deem most appropriate for their particular rights advocacy work, right? So direct incorporation, it's through transformation or transposition of an international treaty. The treaty will form part of national law, be binding on public agencies, and enforceable in court. So a good example of this is the Human Rights Act of 1998, which incorporated the bulk of the European Convention on Human Rights and made it justiciable in domestic courts. I think what is really interesting here is that a lot of people view this as taking the entire treaty and dropping it straight into legislation. And that is often true, but there are various ways that I'm going to talk through. So it's about being more expansive and thinking about how direct incorporation works. So we're going to talk through that. Transformation is one of the ways that has been put forward by the Scottish Government in terms of how to bring an international treaty into Scots law, because they think Scots law is slightly different and needs tweaks, and so transformation has been one of the key ways that they've been talking about this. When they talk about translation, this is the same thing. So they talk about translating international law into Scots law. This means that the language might not be exactly the same. It might not be verbatim language. And most of us that work in the legal field of human rights find we're a little bit uncomfortable with this, because the whole point of using the international treaty is being able to utilize the language of the treaty and the jurisprudence from the international treaty body that interprets the treaty. And I'm going to talk more about that later. But language is very important in the law, and language is very important in judicial opinions and judicial reasoning. So it's very important that we use the same language across the board. And if there are different translations, sometimes that makes everybody talk a different language, and we're not talking about the same right. So transformation is not often the most ideal way, particularly if the translation of a right goes far off of what the international standards set. Because the international obligation is the minimum. It's meant to be a floor, not a ceiling. And I'll say that again, probably repeatedly today. Transposition is the ideal way for those of us that are keen to get full treaties implemented into Scots law. And that is the instance where they take the treaty and drop that language directly into national law. And so that's either by basically a copy-paste of the entire treaty and put it into legislation, or the legislation often will just reference the treaty directly. Say, you know, the entire United Nations Convention on the Rights of the Child will be enforceable in Scots law. Okay? So there are two ways that you could do transposition. Transposition has been a word that's actually been used incorrectly in some of the information that was put out by the Scottish Government during the UNCRC consultation. That's why we think it's really important to understand the difference between transposition, transformation, and translation. The second form of incorporation is indirect incorporation. And so indirect incorporation gives the treaty some effect in national law by means of another legal mechanism. This is generally achieved through a constitutional reference to ratified human rights treaties. So I've put the example of the Chilean Constitution. In Article 5 of the Chilean Constitution, it's my Chilean PhD students back at the back smiling. She gave me this example. And so it incorporates, by reference, the human rights treaties that Chile has ratified. The same goes with South Africa. The same goes with a multitude of states. What their constitution might say is that anything that the state has ratified is part of our domestic law. But it's not always so straightforward. It doesn't mean that they have direct application in every situation. France is a good example of this. Their law says that all their human rights treaties that they've ratified will be part of the national legislation, but then you have to read further down, and it only is if there's direct legislation that gives direct effect that anyone can actually utilize those rights and claim them for their own. So with indirect incorporation, you often need further legislation. Now, that does not mean that with direct incorporation, you don't need further legislation. Just let me say that caveat, because further legislation is often part of doing the finer points of particular rights. But in indirect incorporation, you definitively need further legislation in order to access those rights. And then the final way to incorporate human rights is through piecemeal or sectoral incorporation. Now, up to now, this is the predominant way that the UK or Scotland in general has engaged in implementing its duties under the international treaties. So in this instance, various provisions of the treaty will be integrated into national law. They'll be related to the subject of the broader piece of legislation, but at a level less than direct incorporation. Usually it won't use the language of the treaty. It might make reference to the treaty, but not always. So I've got a couple of examples here. Legislation. So the UK Criminal Justice Act of 1988, it is an example of sectoral incorporation of the prohibition against torture. It criminalizes torture, however, it doesn't utilize the Convention Against Torture definition, which is broadly accepted as the official definition of torture. Through case law, so in instances where judges, they often refer to either UN human rights treaties, not as being binding on their decision-making processes, but as informing their deliberations and their analysis. They often refer to general comments of the treaty bodies, which I'll talk about more. So human treaty body jurisprudence they will refer to. So this is a way of recognizing that there is an obligation, but it might not necessarily be direct or indirect, or piecemeal or sectoral. Okay, so this cross-fertilization is what we generally get in the courts, at least what we've had up to now. And then also in public policy. So public policies often reflect the international standards that the UK has obligated itself to, but it won't necessarily be a direct incorporation of a right. So under the Scottish Children and Young Person Act of 2014, there is the incorporation of the idea that's put forward by the Children's Committee through their general comments that children's rights and well-being impact assessments should be carried out before any legislation is passed to ensure that a child's rights approach has been taken. And because it's not an incorporated duty, we did lots of research last year to determine that actually the way that they engage in this process has been it's been widely variable, and so it doesn't actually really protect children's rights in any meaningful way. So I said I was going to talk a little bit about the treaty bodies. So when we talk about incorporation, I mentioned already that the international standards that are set out in the human rights treaties and all of that list that I gave you at the beginning, that is the floor. They are the bare minimum. And I can say that with confidence because they were negotiated by states. States want to commit themselves to the bare minimum when it is going to take effort, all right? And so these documents set out the bare minimum standards. But we've seen time and again that states can't even commit to that in many instances, and this is why they fail to incorporate. What is also very clear from the years that we've had the international human rights system is that human rights have moved on. You know, the technology that you're using to engage with the Mentimeter, that didn't exist when the ICCPR, so when we first laid out civil and political rights, including freedom of expression. So technology, globalization, so many things that have happened in the last 70 years since human rights were first outlined in the Universal Declaration of Human Rights. Society has changed, technology has changed, the way we live our lives has changed, and human rights have to evolve with that. That's why we call them living instruments, and we talk about the evolutive interpretation of rights, because they can't be static. And the way that we get a good idea about how those rights have moved on is through the treaty bodies. So every one of the treaties at the international level that I had on the screen at the beginning, and that you responded to in the Mentimeter, they all have an attached treaty body that is responsible for interpreting that treaty. And what they do is they have to engage in bilateral communications with all of the states. So every state in the world, 194 UN member states, plus the 2 or 3 states that have questionable recognition, they all are party to at least 2 of the international human rights treaties. The UN Convention on the Rights of the Child has the largest number of states parties. Every state in the world, with the exception of America, is party to the UN Convention on the Rights of the Child. States have made a commitment to implement that basic core minimum of protection for children. So the way we determine and the way we understand how these rights are being implemented across the world, and to establish how they should be implemented in our own country, so in Scotland, is by looking at the information that's produced by the treaty bodies. So the treaty bodies have an obligation, and the states have an obligation to engage with treaty bodies using periodic reports, reading their general comments, engaging with procedures of inquiry, individual communication, and days of discussion. And so these different elements of treaty bodies' processes help us determine the baseline for rights protection and also how rights are changing across the world. It's very important in the context of incorporation that treaty bodies and the jurisprudence and the opinions that they produce are recognized in the incorporation process, because this is the way that enables our courts and our service providers and our duty bearers, so agents of the state, and for individuals to understand what a right means. And it's through this evolving. This, you may remember, looking out, not many of you will remember personally, but you may have read about corporal punishment. So corporal punishment used to be a very liberal practice applied in schools, in homes, everywhere, with children. It was okay to smack your child if they got out of line. But it's through loads of advocacy work and the evolution of what it means to use physical abuse against a child that the world gradually started moving towards, wait a second, it's not okay. Not only is it not okay to do this in public places, and so to be a form of punishment in a school, which were cases that were brought by the UK through the European Court of Human Rights, but it's also not okay in the home, which is why Scotland last year passed a law saying, they withdrew the defense of justifiable assault against children. And these are things that were very much driven by states' engagement with the treaty bodies. And so over time, sometimes it takes a lot of time, that's how we start to learn. I mean, over 100 countries in the world have banned corporal punishment against children. I mean, that's a massive step. So we have to think that when we're trying to accumulate the world's knowledge of rights and the world's implementation of rights, it takes some time. But it's important that we take heed of the treaty bodies and their views. So like I said, across all the functions of the treaty bodies that I just discussed, this is where the language of human rights is really developed. And how we use that language in our day-to-day human rights advocacy work and in our courts and in our government offices, that is important. But it's also important about how we use it in and amongst just the general population so that we have a common understanding. Treaties establish a baseline, so they are the floor, not the ceiling. We can always do better. Treaty bodies tell us what that baseline is as a legal concept, and treaty interpretation evolves with society, as I said. The treaty and interpretation language is important, but it's not the only important source of understanding human rights. The Human Rights Council is another UN mechanism where we get information about how human rights are being addressed across the world. It is not necessarily treaty specific. It is predominantly focused on the Universal Declaration of Human Rights, but it's a good gauge about how rights are being either protected or in most cases not protected generally across the board. What's important for our purposes, I think, is that the Human Rights Council basically oversees the special procedures. Just show of hands, how many of you knew of or engaged with Philip Alston's visit when he was here as the Special Rapporteur on Poverty? Okay, so a couple of you. You no doubt, if you weren't involved in or engaged in his visit, you no doubt read in the papers the scathing reports and the scathing responses to his report about the UK as one of the world's strongest economies that actually had the most rife poverty, particularly among children. So these special rapporteurs, they develop this. They do a lot of work to actually gather information and engage with people on the ground when they go in countries. And so when they produce these reports, it's not just for fun. I mean, I think people, and particularly in some of the media reports about his visit, I think they kind of suggest that he's doing this for some kind of cause. But actually, he's an academic, just like me. He doesn't get paid to do his job. He does it for free. He spends 3 months out of the year doing nothing but visiting countries and developing reports. And he does it because he thinks it is important and he wants to make a difference. And so it's important that we read these reports and think about the ways in which these reports can shape our understanding of rights and how they might not be accessible to individuals in the country. They also engage with the the Human Rights Council is responsible for the Universal Periodic Review, which is how every state in the United Nations is reviewed on their human rights record. It's important because sometimes that's the only way that we get any kind of glimpse into a country and its human rights situation. So even countries like North Korea engage. For Scotland, it's important because in the Universal Periodic Review process, the back and forth, so the bilateral communication between the Human Rights Council and the United Kingdom also involves very specific devolved nation points of information. So if there's something that's going on in one of the devolved nations, that point might be raised in the Universal Periodic Review. So it's always important to understand that they also have a role in reviewing the way in which human rights are implemented in the United Kingdom. I'm going to close it there, okay? Thank you.